silent. Court is again in session. Please be seated.
Good afternoon. We're very excited for the second part of our day. And so will the clerk please call the case?
While I'm reconnecting, may I have your spelling? Kind of depends on technology and it goes down. The case today is Dragontown University, the petitioner, versus Dr. Peter Foster, the respondent. And this is docket number 4103.
First.
Hello, and may it please the court. My name is Chris Weed, and I am here proudly representing Dragontown University in this case. At this time, may I please request 2 minutes for rebuttal?
Certainly.
Thank you. While the First Amendment is a cornerstone of our great American democracy, it is not a blank check for government employees to use controversial speech. And here, Dragontown University should be able to curtail the speech of Dr. Foster for 3 main reasons. First, Dr. Foster spoke pursuant to his official duties. Second, no academic exception should apply. And third, whether or not this court decides Dr. Foster spoke as a citizen or pursuant to his official duties and an academic exception applies, the Connick-Pickering analysis should follow, and there, Dragontown's interests in financial stability and efficiency vastly outweigh that of Dr. Foster's.
Counsel, other than the email, in what way do you believe that his statements constitute an official, were made in his official capacity?
The main reason that Dr. Foster's speech was made under his official capacity as a professor for the university was that it falls underneath his formal job description. Now, while it is clear in Garcetti this court did hold that formal job descriptions are neither sufficient nor necessary in order to prove someone acted or spoke pursuant to official duties, it is a factor, and that factor is present here nonetheless. And it is present because Dr. Foster says it is present in his own words on his website. I point you to the record at page 4, where Dr. Foster says he published medical articles to foster scholarly debate on his website. And here, Dr. Foster's formal job description, which is at page 3 in the record, says he was to further the academic mission of the school by conducting research, scholarship, and furthering discourse. And that last section right there is what matches up with Dr. Foster's speech. And in addition to the formal job description is also the fact that Dr. Foster explicitly and implicitly tries to link his speech on the website to his job at Dragontown University. First and foremost, by the name of the website itself, drfostertown.com is a clear reference to dragontown.com. And that, in conjunction with the reference to Dragontown on his biography page, and the fact that Dr. Foster signs every single blog post with his Dragontown email address, suggests that not only he believes that his blog posts are related to his job duties, but he also wants the readers to believe that as well. So those are the 2 main reasons. And then moving forward, no academic exception should apply to his speech for a couple different reasons. And the law in this area asks the court to choose 1 or 2 paths. It can follow the Seventh Circuit, as the Seventh Circuit stated in Rankin v. Gee, where there simply is no academic exception. And the court failed to even do that analysis because there is no academic exception as yet laid down by this court. But perhaps a more palatable answer to this question is that of the Sixth and the Third Circuits in Gorham v. Sessoms and Savage v. Gee, where the court held there very well may be an academic exception. And academic speech is important, but the facts of the case do not fall within that definition. And here, As there, the court looked at where the location took place, or where the speech took place. Was it for students? And how closely related to what the professor teaches in the classroom was the speech? And here, if you look at those factors, the speech occurred outside the classroom, was meant to be kept away from students, and was removed from what he actually taught at the university, because he taught surgery at the university, not neurology, as his post was all about, and epilepsy and things such as that matter. So with that, the court should proceed to the Connick-Pickering analysis. And the first step of that is the Connick analysis, which asks this court to question, was what Dr. Foster said a matter of public concern? And this court has defined that very broadly as any political or social matter of concern to the community. So clearly here, Dr. Foster's speech, when it talked about the overuse of pharmaceutical drugs in a country and a state that has been ravaged by the opioid epidemic that has struck this country, clearly that language touches on a matter of public concern. So with that, the court should proceed to the Pickering analysis, which is a simple balancing of interests between the government and the government entity and the citizen who spoke on the matter. And there, Dragontown has two interests at stake. One, it has its efficiency at stake, and that was put at risk by the protest on school campus, the cancellation of class. The main office received several calls from angry undergrad students voicing their concerns, and because of that, the dean saw the possibility of a drop of enrollment. Now, the second prong of our interest argument is that the financial stability of the university was also put at risk. The university received a letter from a donor that threatened the withdrawal of funding to the school. And that letter came in conjunction with a letter from alumni, several members of the alumni, who voiced their concern over Dr. Foster's speech. And so reasonably, the dean foresaw troubles with the funding of the school, and that other donors could also threaten withdrawal, and that eventually money could be taken from the school's coffers. Now, adding to our interests are a couple factors that this court and the Seventh Circuit have held add more weight, if you will, to the scale of the government's interests. The first of which comes from a case called Craig v. Rich Township from the Seventh Circuit, where that court found that when a school's services are disrupted, the interest of the government is heightened even more because of the special place of education in our system. And there, you had similar facts. You had a school counselor that wrote a privately funded book. This book spoke about relationships between men and women, but that book sexualized women and talked about them in a very graphic way, which was unbecoming of a school counselor. And while the community was outraged, the board of directors of the school district made the decision to fire the school counselor prior to it becoming common knowledge on school grounds, because it found, and the court also found, that it was very likely that once this sort of information was disseminated through the student body, that students would be less likely to seek out the services of the school counselor. That is the same situation we have here. At Dragontown University, because of Dr. Foster's controversial speech, students are going to be less likely to seek out his services, whether it be in the classroom or just simple advice that students seek from their professors in their spare time. In addition...
But you were talking earlier about the inconvenience to the school, the possible loss of donors and so forth. Are those really a good balance with his freedom of speech rights?
Absolutely, Your Honor, because not only does it affect the university, but it affects every single student that goes to the university. If the school cannot run efficiently, if the school does not have money in its coffers to provide for the students, then it affects not just the university, but every student who seeks to get an education from the prestigious university that is Dragontown.
Well, isn't that a chilling effect? Then should every professor, before they post anything, either connected to the university or not, to university administration to get their approval to say this is satisfactory? Because absent that, anything you say And we know in this day and age, virtually any comment can stir up trouble, and alumni get frustrated, and potentially donors pull their money.
No, Your Honor, we don't believe that. We believe that when this sort of situation strikes at a school and affects so many others other than the university, that the interest involved here is so great and so burdensome that it outweighs any of those concerns.
Where do you draw the line?
Well, Your Honor, here I ask you to draw the line and say that the academic exception is meant for classroom speech. Classroom speech. This occurred outside of the classroom, and in fact was not even targeting the students. And as this is not the type of academic speech that Justice Soter had in mind in his dissent in Garcetti when he even brought up the possibility of an exception whatsoever. So with that, I would argue that a teacher on a campus, in a classroom, perhaps in an auditorium speaking to students is a totally different ballgame than a government employee speaking on his own time in a way, and to reference your question, in a way that affects the interest of the university.
So if he had done this in the classroom, would it have been protected?
Absolutely, Your Honor. That is where the academic exception, if there is one, should be reserved for. Absolutely. Because we are not trying to say, as the university, that professors cannot go out and espouse their beliefs. We're just saying you can't do it in a way that affects the institution, the government entity, in such a negative way, and takes money out of its coffers and potentially loses students because of that.
Well, that's a hard distinction for me to make. That's okay to talk about this in the classroom, but you can't write, say, a journal article, or even if it's way off base with the general medical community, you can't write an article that differs with the medical community?
Our argument is that no, you cannot, as long as that article affects our interest in such a negative way. The school here has to protect its ability to function, and that's what it did when it acted. And it only acted after the disruptions had actually occurred. It did not act when the speech was first published. It did not act when there was an original article wrote about the speech. It only acted when the school's ability to function was put at risk and was threatened by the school cancellation, the class cancellation, and the school protest that happened on campus. And then lastly, Your Honors, especially if this court holds that Dr. Foster spoke pursuant to his official duties, the blog post clearly represents that Dr. Foster was speaking in a public contact role, which this court in Rankin v. McPherson held adds even more weight to our scale, because there the government has an even bigger interest to curtail the speech, to control the speech, and to make sure it meets the standards of that government entity. So with that, Dragontown University respectfully requests that this court reverse the ruling of the 14th Circuit Court of Appeals, because Dragontown University should be able to curtail the speech of Dr. Foster when that controversial speech prevents Dragontown University students from receiving any academic speech whatsoever. That is the crux of this case. That is Dragontown's argument, and for that reason, this court should reverse the lower court.
Counsel, if you take the position that you've taken that this had to be in the classroom in order for it to be protected, does that, the fact that it wasn't in the classroom, weigh on the opposite side of that equation, that it's just his personal view? It's not something that reflects upon the college. It's just him expressing a personal view on his own website?
It very well may be, but with the fact that his speech was said in a way that was connected so much to the university, the name of the website, his signature on the blog post that were his Dragontown University email address, that changes the equation, because now he's not speaking as a citizen, he's speaking as an employee of the government entity and making statements that affect its interests. And with that, I see that my time is up, and we respectfully request a reversal in this case. Thank you.
May it please the court, my name is Emily Ford and I represent Dr. Peter Foster. The freedom of speech is a fundamental principle of education and academia. When a government employer impedes upon the free speech of one of its employees, the government must demonstrate an overriding interest that goes beyond mere speculation. When Dragontown University fired Dr. Peter Foster for statements he made on a private blog, they failed to reach this burden and violated his First Amendment rights to free speech. This court should affirm the holding of the 14th Circuit for the following reasons. Firstly, by expressing his opinions on a private blog, Dr. Foster did not act pursuant to his official duties as a tenured professor at Dragontown University. Secondly, Dragontown University has shown no overriding interest or adequate justification to support firing Dr. Foster for statements he made as a private citizen regarding a matter of great public concern. And lastly, protecting academic speech is essential to maintaining the integrity of the First Amendment, and the employer power outlined in Garcetti should be construed narrowly. When Dr. Foster wrote his blog on January 14, 2016, he did not act pursuant to his official role at Dragontown University. Dr. Foster's blog post was specifically kept out of his classroom. Never once did Dr. Foster engage with students regarding some of his unconventional beliefs espoused in this blog post. Dr. Foster's blog also has a very significant makeup. While Dr. Foster's blog does feature articles regarding medical discourse, a majority of his blog was more personal in nature. Dr. Foster's blog featured satirical articles that he found humorous and interesting. It also featured personal family photos from vacations. Dr. Foster's private blog was also not funded, commissioned by, or required by his role at Dragontown University.
But what about the fact that he used his Dragontown email address?
Yes, Your Honor. Dr. Foster did use his Dragontown email address to set up the website. The website in which Dr. Foster's blog is featured requires that an email address be used to create the website. And Dragontown University does not have a social media policy that governs when an employee or staff member can and cannot use their email. Dr. Foster's email and biography page were the only connections to Dragontown University. In particular, Dr. Foster's blog page was simply made to tell visitors of his blog a little bit about Dr. Foster. While it did mention that he works at Dragontown University, his blog page also included his educational background at institutions that are not connected to Dragontown University. Dr. Foster's email was again used simply to set up the website and not an attempt to bolster his credibility with his viewers.
Let me ask you, you mentioned your second element of the overriding interest. You know, you've got a doctor who educates future physicians, and by all accounts, what was posted was in no way, shape, or form mainstream medical thought of treatment. Doesn't he have a responsibility under the color of being a university professor connected to this medical school to not have quackery in his medical advice that he clearly people obviously led to a death here, relied upon? Where's the responsibility?
Well, Your Honor, Dr. Foster specifically kept any of his unconventional beliefs, specifically regarding epilepsy, out of his classroom. However, the majority of Dr. Foster's blog post focused on an issue that is a great matter of public concern to the entire medical community, and that is the over-reliance on pharmaceuticals shown by doctors in our country. This matter is a matter of great public concern that will affect all medical students as well as all individuals who have been and will be a patient again in their lifetime. The over-reliance on pharmaceuticals is one of the reasons for the opioid epidemic in this state as well as our nation. This is a matter of global concern, and Dr. Foster's blog simply urged viewers, patients, and doctors to seek alternative treatment methods. While some of Dr. Foster's statements are unconventional, this statement about pharmaceuticals is absolutely a matter that concerns the public. Dr. Foster's blog post, while it was completely kept out of his classroom, cannot be connected to his job duty in any way at Dragontown University. Dr. Foster's duties at Dragontown University include teaching classes, engaging in research, scholarship, and fostering debate to further the mission of Dragontown University. And in our case before us today, Dr. Foster's blog post is not connected to his job at Dragontown University, aside from the general notion that professors engage in discourse. This court has explicitly rejected excessively broad job descriptions such as this one, and the general notion that professors engage in discourse in their respective fields is not connected to a specific duty that would render Dr. Foster's statements pursuant to his official duties. My opposing counsel has already conceded today that Dr. Foster's blog post featured articles and featured statements that are a matter of great public concern, which satisfies the first element of the Connick-Pickering balancing test. Dragontown University has demonstrated no overriding interest that would justify impeding upon the free speech of one of their professors that was made by a private citizen regarding a great matter of public concern. This court in Connick v. Myers held that the greater the matter of public concern, the greater the interest that must be shown by the government entity to impede upon that speech made pursuant to that great matter of concern. And in this case, Dragontown University has simply not met this burden. Dragontown University contends that a sit-in, a handful of phone calls, and a letter by 10 disgruntled alumni are sufficient to override Dr. Foster's free speech, and that is simply not the case. Beginning with the sit-in, while a single class was canceled on campus at Dragontown University, this is an isolated instance that had no effect on Dragontown University's day-to-day function. College campuses are the historical birthplace of sit-ins and protests, and it is only natural that these students would also want to exercise their First Amendment rights and speak pursuant to what one of their professors has been saying. And also, these students simply exercise their right to free speech, just as Dr. Foster did when he wrote his private blog. Any unpopular campus initiative would have had the same impact on campus as Dr. Foster's statements. This is clearly not an overriding interest that would justify hindering a man's free speech. Secondly, Dragontown University contends that its funding was jeopardized when a letter was written by 10 prominent alumni. However, this does not meet the burden that must be shown by Dragontown University and is in fact mere speculation. This court and United States v. National Treasury Union held that mere speculation is not sufficient to establish an overriding burden.
So would you have had the Dragontown wait until real harm had occurred? I mean, at what point should the university have the discretion to take action in the face of what appeared to them to be a serious problem?
Well, Your Honor, in this case before us, no real harm has occurred to Dragontown University. And while Dragontown University does not have to wait for that harm to occur, they must show that a harm may occur beyond mere speculation. And in this case, the letter written by the 10 alumni does not mention funding whatsoever. That letter can be found at Exhibit C, and this letter simply reiterates the fact that Dr. Peter Foster is an unconventional thinker, and that unconventional thinking has no place at Dragontown University.
Well, doesn't it hurt the medical school's reputation if we have this guy that's, thinking outside the box and someone dies as a result of taking his advice?
Well, Your Honor, while Mr. Romero's death is unfortunate, it is not connected to Dr. Foster's statements on his blog beyond his own doctor's initiative to take those statements and apply them to her patient. Dr. Foster's blog simply urged physicians to seek alternative treatments with their patients. He even features a section on this blog post that states, if these physicians do not agree with his methods, it is still their duty to discuss these options with their patients. While Mr. Romero's death is unfortunate, it is not the result of Dr. Foster's statements. It is the result of Dr. Woolley's malpractice. And in this particular case before us, Dr. Foster's statements did not impact Dragontown University's reputation. Just because the trial became public at Dragontown University, there has been nothing in the record to show that Dragontown University's reputation has been damaged by Dr. Foster. These undergraduate students who called Dragontown University to complain about Dr. Foster are very similar to the statement that I just made about speculation from the letter. These statements could have come from any individuals at Dragontown University who didn't agree with Dr. Foster and who wouldn't agree with any unpopular campus initiative. This could be the same exact result. Dr. Foster's blog post was not hindering Dragontown University's function or efficiency, with the exception of these isolated instances. And Dragontown University has failed to show an overriding interest there that would justify firing Dr. Foster or even hindering his speech. This court in Rankin v. McPherson established a comprehensive framework that could, in fact, weigh in favor of Dragontown University if met. That framework established that statements that hinder job performance, work personnel relationships, and the work of the professor making those statements. If Dragontown University were to show any of these, this could be a weight in favor of Dragontown University. Not an overriding weight, but they are factors to consider. And here, Dr. Foster's statements had no impact on work, job performance, or personnel relationships at Dragontown University. In fact, there is nothing in the record before us today to suggest that students stopped attending Dr. Foster's classes. His blog post went viral in the beginning of January, and he was not fired until the middle of April. Students continued to attend Dr. Foster's classes without issue, and with the exception of the protest class that was canceled, there is nothing in the record to suggest that Dr. Foster's work performance was affected at all until Dragontown University removed him from the classroom. Dr. Foster continued to teach his students, and he continued to be a well-respected professor at Dragontown University. Dr. Foster's personnel relationships on campus were likewise not hindered by his statements in any way. Dr. Foster's colleagues knew that he was an unconventional thinker. They had heard some of these thoughts at social functions, Christmas parties, and in private conversations. None of Dr. Foster's colleagues would be surprised or disturbed to hear about his blog post or his unconventional beliefs. And in fact, many of his colleagues would absolutely agree with his comments about pharmaceutical usage, which is a major issue on medical universities across the country. And lastly, Your Honors, protecting academic speech is essential to maintaining the integrity of the First Amendment, and the employer power outlined in Garcetti should be construed very narrowly. This court has consistently held that academic speech occupies a specific and special niche in the constitutional tradition. Protecting alternative thinkers like Dr. Foster is essential to preventing orthodoxy in the classroom. And the First Amendment has never upheld any laws that cast a pall of orthodoxy over the classroom. In particular, this court in Sweezy v. New Hampshire and Chief Justice Warren specifically argued that this court should be reticent to tread upon the freedom of speech, particularly in the classroom. And while Dr. Foster's statements were not made in the classroom, they certainly could be made in his classroom, particularly his speech regarding pharmaceutical usage. Medical universities across this country are going to have to tackle the opioid epidemic. Doctors and medical students are going to have to begin to seek alternative treatments, and that will be a great discussion in medical university classrooms.
You keep emphasizing the importance of the public issues, but in Pickering, it clearly stated that if there was, the speech was associated with making knowingly or recklessly false statements, that limits your entitlement to free speech protection. And I don't know that there's anything here that suggests what he posted was anything but reckless.
Absolutely.
So he doesn't he then lose, or doesn't he automatically lose as a result of the fact of what he said was reckless and knowingly false? That he loses his entitlement to First Amendment rights, even though he's advocating, as you suggest, a public interest issue relating to pharmaceutical usage?
Well, Your Honor, Dr. Foster's statements were not reckless. We do not know, given the record before us, exactly what research Dr. Foster put into these statements. All we know is that some members of the medical community are against his epileptic practices. However, even if Dr. Foster's statements were reckless, that would only be a weight in favor of Dragontown University. It would not be sufficient on its own to show the overriding interest that Dragontown University must demonstrate to impede upon Dr. Foster's free speech. It seems I am out of time, Your Honor. May I briefly conclude?
Certainly.
Thank you. For the foregoing reasons, this court should affirm the holding of the 14th Circuit and find in favor of Dr. Foster. Thank you.
Just to respond to a few points, Your Honors. First and foremost, with the speculation language that was cited by Dr. Foster. Dragontown University does not have to wait for disaster to occur on its campus before it takes action, and to hold otherwise would be an unreasonable standard. And this question has already been answered by this court in Connick, and I quote to you, Connick. This court does not see the necessity for an employer to allow events to unfold to the extent that the disruption of the office and the destruction of working relationships would be manifest before taking action. In other words, Your Honors, Dragontown University does not have to wait. And if it did, how much money must be taken from its coffers? How many students must be prevented from going into the classroom? And how many protests must occur before it is justified in firing Dr.
Didn't
Foster?
the 14th Circuit just say he deserves to have a hearing?
Yes, Your Honor, it did. And we wanted to provide Dr. Foster with a hearing, and we gave him an email saying we would like to meet with him
Well,
to
that's
give
not,
him that
that's
hearing.
not exactly notice of a hearing, though. Just, we'd like to meet with you. Is that all it said?
It said we would also like to discuss the recent allegations, I believe, and that exhibit is on page 11 of the record. Additionally, Your Honors, Dr. Foster admitted in the argument that his speech was not for students. So I implore the court to ask, how can speech not meant for students be academic in and of itself?
Well, aren't professors, both in medical schools and law schools and otherwise, urged to do academic writing and so forth for the general population
Yes, ma'am.
of other professionals?
Yes, ma'am, to further the academic mission of the school they work for. And here, clearly, Dr. Foster's speech did not do that. It was controversial, it was reckless, and clearly it was false as it resulted in a man's death. And for those reasons and the foregoing reasons, I respectfully request this court reverse the ruling of the 14th Circuit. Thank you.
Thank you. This case will be submitted.
All rise. We next stand while the justice leave the room, recess for approximately 10 to 15 minutes.
know the date that you want to bring them down to the court?
It is,
Oh, you have it? Good.
yeah, it's, and we're going to take him to the bar.
Right.
I believe it's the 25th.
Of what?
I was really like, oh, I have a very long conclusion. I saved it with another question.
Yeah, yeah. Well, I'm just gonna say, because you had about, once I felt like you were getting ready to wind down, you had about 220 left, and then I was gonna say question.
Thank God, let me run that.
That's all I was. I'm like, this is kind of an in-depth question to answer, and I'm sitting there. Right. I mean, that's a popular question. Right. I know what you're gonna ask me the answer. Well, great.
Left it all out there. I got everything all already set there. I was waiting for it in rebuttal. I was like,
All rise and be silent. Are we ready? Court is again in session. Please be seated.
Well, we, all the time are called upon to make hard decisions, but this is probably the hardest because you two did an excellent job. You clearly were well prepared, poised, had great command of the materials, but it came down to there was a little yelling. We tried to keep it down. A little disagreement, but in a very close call. Emily, congratulations.